Hi, everyone. Welcome to the Veterans Legal Lowdown. My name is Maura Black. I'm a partner here at Chisholm Chisholm Kilpatrick. I'm joined today by Ethan Muckelbauer. Ethan, tell us a little bit about yourself.
Yeah, I'm a supervising attorney, and I've been at CCK practicing veterans law for over 5 years now.
Amazing. Today, we're bringing you 4 segments on the topic of VA claim tips. The first, all the ways to get service connection, including some theories that you may not have heard of before. Second, the most confusing terms in VA benefits. That's going to be a fun one. Then we'll move on to a practical guide on how to request evidence from the military or from private parties that can help support a claim. And finally, we'll close out with a list of the hardest claims to win. Before we get started, please remember to like, subscribe, comment, and share this video. We really appreciate your feedback and your questions. Different ways to establish service connection. We're talking about 5 of the primary legal ways to establish that an injury or illness was related to a person's military service. The essence of service connection is governed in statute. It's 38 U.S.C. 1110. This is the statute that basically provides a pathway for connecting an injury, illness, or medical condition to service. But beyond that, there are several VA regulations that govern the more precise ways to get service connection. And there's lots of different angles or theories that a veteran could pursue if they have an injury or illness that is somehow linked to their time in the military. So, Ethan, will you start us off with the first pathway, which I think is the cleanest one, and it's direct service connection?
Yeah, so direct service connection, probably the most common type of service connection theory that we see. VA is going to be looking for 3 things with direct service connection. They want to see first a current disability, second, some sort of injury or event that happened to you in service, and then third, a nexus that links those 2 things together. So there's a few specifics about what you need to submit to prove. You can use service records, medical records, a VA examination, also lay evidence. Lay evidence is important, and the law says that VA still has to consider it. However, for a diagnosis, you're generally going to require medical evidence from a treatment provider, from one of VA's medical examiners, someone who has medical expertise to actually diagnose a condition. And then same with a nexus, connecting your current disability to service is also going to require some form of medical expertise. However, you can still use lay statements to describe what happened to you in service, your injury, your history of symptoms since that injury, and it can still be a really valuable resource to support your claim.
Great.
So the key takeaway, though, is that direct service connection is about linking your condition directly to service. You don't need a flawless claim. You just need to prove those 3 elements.
Exactly. And you mentioned lay evidence, and there's plenty of court cases that we talk about in videos and put on our blog. Buchanan comes to mind, Fountain. This line of cases confirms that lay evidence is important and needs to be considered to the extent that the person can speak to the circumstance that they're describing. As Ethan mentioned, there are times when medical evidence is needed, but for anyone working on a direct service connection issue, lay evidence surrounding the circumstances that you're trying to prove to VA can be really helpful and powerful. The second pathway to talk about is secondary service connection. This is governed by 38 CFR 3.310, and the CFR is the Code of Federal Regulations that govern VA regulations that we apply all the time in our claims and appeals. And secondary service connection applies when a service-connected disability causes or aggravates another condition. So, for example, if a veteran sustains a leg injury in service, they might seek direct service connection and ask for benefits for that leg injury because it occurred in service. But then if that leg injury leads to other issues later, like secondary joint pain, maybe some back pain as a result of like an altered gait or something like that, stemming from the leg injury, then anything that does stem from the leg injury can also be compensable. And that's the secondary service connection theory. There's lots of different ways that different types of in-service injuries could lead later in life to progressive worsening or even causing some other injuries.
Some common ones we see are complications of diabetes or even treatment for a disability. If you go through chemotherapy or treatment for a cancer and have additional disability because of that, that is also eligible for secondary service connection if the primary condition was related to service. Exactly.
That's a great point too about medication. We've seen cases where sometimes even psychiatric medications or other types of medications for a directly service-connected injury could lead to side effects like hypertension. And so those things are important to keep in mind. VA will not always service connect those things, and you might not even have those issues at the time that you're seeking direct service connection. So over time, if a service-connected illness causes or aggravates another one, then keep in mind the secondary service connection theory.
Yeah, so the third pathway is presumptive service connection. This is where VA law steps in to fill in some of the facts that might be difficult for veterans to prove. Some of the important statutes here are 38 USC 1112 and 1116. There are a few other regulations like 38 CFR 3.307 and 3.309. This says that VA presumes service connection for certain conditions or presumes exposure based on service in certain locations. So this includes chronic diseases if your certain disabilities manifested within a year of service, Gulf War exposure, conditions related to herbicide exposure, all sorts of toxic exposure. VA has identified certain conditions that they will just automatically associate with that exposure. So one example is the presumption of herbicide exposure for veterans. So if a veteran served in Vietnam or Thailand between 1962 and 1975, the veteran doesn't have to prove actual exposure. They just have to show service in the location. Then the law steps in to just assume that veteran was exposed. Similarly, certain conditions are associated with certain types of exposure. So Camp Lejeune exposure has bladder cancer, breast cancer, other disabilities. Again, the veteran doesn't have to prove the nexus. They just have to prove they served at the location, they have the disability, and the law steps in to fill everything else. Importantly, presumption doesn't mean automatic service connection. You're still going to need to show you have this disability through medical records. You're going to need to show that you served in a certain location to qualify for the presumption. But it does remove a lot of the burden of some of the really hard stuff to prove for veterans. You know, it's very hard to produce evidence that you were actually exposed to Agent Orange. So that's why these presumptions exist in the law, to make it a lot easier for veterans to establish those parts of their claim.
Exactly. And it's good to know about which presumption applies to you, what specific burden is relieved from the person claiming the benefit. As Ethan mentioned, there are some presumptions that exposure occurred if you had service in a time and place. There's also some presumption that an in-service event caused another thing. So sometimes we're taking away the in-service event requirement that you talked about a few minutes ago. Sometimes it's nexus. So there's still work to be done, but usually the presumption will help alleviate the burden, at least as to one of the service connection prongs. Another pathway to service connection, this one's a little complicated, service connection by aggravation. So as a general rule, the presumption of soundness exists to say that if a person entered service without any conditions noted on their entrance exam, they're presumed sound at entry. So unless there's evidence that a condition pre-existed service and was not aggravated by service, then a veteran is presumed to not have that condition at the time that they enlisted. So later, maybe if they develop something, they could get benefits for that condition. But if a veteran does have a condition that pre-exists service that was aggravated during service, they may be able to seek service connection under 38 USC 1111 and 1153, and also through the regulation at 38 CFR 3.306. These are pretty complicated issues. The presumption of soundness is a very legalese sort of set of requirements or parameters that's established, and the law wants to protect veterans from later being told by the VA, like, oh, no, actually, this injury that you claim stems from service actually pre-existed service. And that's all good. But if a veteran does have an issue that pre-existed service, there is still a pathway to get service-connected benefits for it if they can prove that it was aggravated beyond the natural progression of the condition during their time in the military. So episodic, temporary flare-ups, that's not going to be enough to establish service connection by aggravation, but showing that the condition was permanently altered or, substantially worsened for the long run during service is one way to get benefits for a condition that did pre-exist service.
So speaking of complicated, last up, we have 1151 claims. So this is under 38 USC 1151, and there's a regulation 38 CFR 3.361. 1151 claims involve veterans suffering additional disability as a result of VA medical treatment, surgery, or care. So you can get compensation if you develop a disability due to medical negligence, lack of proper skill, error in judgment from a medical professional, or an event that occurs during treatment that is not reasonably foreseeable. Reasonably foreseeable means it's not an expected complication or issue with that treatment. So known risks associated with a surgery, for example, are probably not going to qualify for 1151 benefits, even if they did result from VA treatment. However, any unforeseen consequences of a surgery or treatment at VA, you're eligible for disability compensation. They're paid as if the condition is service-connected, but it's not quite the same as traditional service connection. You're not establishing a direct relationship to service. It's more about the harm resulted from treatment at a VA facility, and it was some sort of medical negligence or unforeseen complication. Medical evidence in these cases is essential. There is a lot to show that it was, negligence or an error in judgment of the medical professional and not a routine complication of the surgery. So getting evidence on the foreseeability, the fault, what happened during the procedure is really important. It's also important if you signed any consent forms prior to the treatment, take a look to see what they informed you of, because that might make it much harder to prove you're entitled to compensation for those.
Great. Thanks, Ethan. So in a nutshell, 5 different pathways to service connection: direct, secondary, presumptive, aggravation of a pre-existing issue, and based on claims governed by 1151, as Ethan just mentioned. Some of these are simpler than others, as we've talked about, but all of them involve some burden on the claimant to produce evidence to show the link between their service and a condition that they now have. So we recommend that if anyone's working through some of these more complicated claims, definitely seek the advice of an accredited representative that can help you navigate the different legal requirements that come along with demonstrating and proving any of these service connection theories. And one final note, you can pursue multiple theories at the same time. If you have a condition that may be related to service and you're not exactly sure what theory to invoke, it's VA's duty to explore all avenues that could lead to a grant of benefits. So don't be afraid to raise multiple theories if you're not exactly sure. A layperson without medical knowledge isn't expected to have all the answers on this type of thing anyway. Now we're going to talk about some confusing terms in the VA process. If anyone has had even 5 minutes of exposure to the VA claims and appeals process, you know that there's some really confusing terms, phrases, terms of art that VA uses. We picked a few that we want to quickly walk through, and we're hoping that this demystifies and kind of clears up some of the legal jargon that can come along with this process. Ethan, let's start with what nexus means.
Nexus. So if you've dealt with the VA at all in the claims process, you might have seen them say you didn't prove a nexus or we need to show a nexus. A nexus just means a medical link between a disability and a cause. So some sort of medical connection. So as we mentioned in our earlier video, service connection requires 3 things. For direct service connection, a current disability, an in-service event, and then the nexus, the connection between those 2 things. This is almost always going to be proven through a medical opinion. So laypersons don't have the necessary training in VA's eyes to say what caused their disability. So it's important to get medical language from a private doctor or a VA examiner. What VA is looking for is whether the condition was at least as likely as not caused by service or another service-connected disability, which roughly translates to over 50% likely. Court cases like Shedden v. Principi have made clear that you can't get service connection without a nexus. It's an essential part of that claim. And the more specific your nexus evidence is to your own disability, as opposed to general medical articles, the more helpful it is to prove your claim.
Great. And even though nexus is hugely important, there's also the idea of a presumption. VA has presumptive rules. You may have seen that term. What does presumption actually mean, and how does it apply to my claim or appeal? A presumption is when the law presumes that a fact is true without requiring the claimant to produce any evidence as to that fact. So We've talked about presumptions in a lot of our materials that we have online. The most common one that I always think of is herbicide exposure is presumed if you were in certain places of service with certain dates. These are all defined by regulation. If you want to look more at regulations that talk about presumptions, because there are many, and they tend to be pretty nuanced, you might want to look at 38 CFR 3.307 and 3.309. Basically, so a presumption is a shortcut that's built into the law. Ethan talked a minute ago about nexus. Well, the burden to demonstrate a nexus is actually relieved if there's a presumption that presumes that a certain condition is related to radiation exposure or herbicide exposure, or if you need to demonstrate exposure, the law might take care of that by saying that your places and times of service are consistent with such exposure that the law will presume it. Mm-hmm. So presumptions really do help claimants relieve the burden of having to prove certain facts, but it is important to read the specific regulatory provisions because they can be pretty nuanced, limited. Hopefully that's helpful, though. It's kind of saying there's more information that you need to get, but if you see VA applying a presumption or a presumptive rule, that's the essence of what that means.
Yeah, so next up is actually going to be the word benefit, which funnily enough is one of the more confusing terms in VA's world. People hear the term VA benefits and they kind of think of a reward for good behavior or good service or some sort of additional benefit for all veterans, regardless of their disabilities or medical history. They might also think it's like charity or a handout or, some sort of social benefit or reward. Really, that's not what VA benefits are at all. It's kind of a misunderstanding of how VA thinks about their own benefits. And it can actually make veterans less likely to file claims because they think there's something shameful about it. Or if you're like they're asking for something they didn't earn, a handout. Really, the idea of VA's benefits, disability benefits, is to compensate veterans for what they call loss of earning capacity. So Congress recognized that when you have an illness or disability because of service, it makes it harder to work. It makes it harder to earn money and earn a living. So it's baked directly into the statute. It's 38 U.S.C. 1110, and then VA's own ratings that the percentages they assigned are to compensate you for your loss of earning capacity, your lessened ability to earn a living. In that sense, VA benefits are probably closer to workers' compensation benefits after an injury on the job. They're really meant to compensate you for those service injuries and problems that just make it difficult to function in day-to-day life.
That's a great segue into the next term on our list, which is the rating schedule. VA has a massive series of regulations in the Code of Federal Regulations that we've talked about a lot. 4-point, insert your regulation here. There's a whole series of regulations that govern the different types of ratings that VA will assign based on a service-connected disability or condition and how it manifests. So as Ethan mentioned, the point of VA benefits is to compensate individuals for loss of earning capacity and the functional impact that their service-related disabilities cause. And the rating schedule defines exactly how each condition should be rated individually based on how different conditions manifest as symptoms. So for example, the psychiatric regulations or rating criteria in the rating schedule talk about a series of symptoms or impairments associated with a 0, 10, 30, 50, 70% rating. That same scheme applies for all of the different conditions that veterans can be service-connected for. So if you have questions or concerns about how VA is rating the individual disabilities that you have, the rating schedule is a great place to look to see what are the criteria for the higher rating or the lower rating. Why does VA think that my symptoms are consistent with this rating? The rating schedule is probably going to tell you exactly how VA rates the conditions for which you're getting service-connected benefits.
Yeah, and those percentages are assigned based on what VA thinks is kind of the average loss of earning capacity. So a 20% for a back condition is saying that generally, if you have these back symptoms, your ability to work is reduced by about 20%.
Exactly. And that can be a tricky concept because I think there's a lot of subjective experience of symptoms and impairments. There's things beyond occupational impairment that are relevant to people, humans living with medical conditions and disabilities. It's more than just can they show up to work.
Right.
But VA does anchor the scheme of regulations and the scheme of ratings based on that sort of North Star of impairment and earning capacity.
Yeah. So next up is the bilateral factor. You might see this on a rating decision or VA list of your code sheet, your current disability. The bilateral factor is something VA applies when both sides of your body are affected by a disability. So if both legs, both arms are impaired, both feet, VA is supposed to add an extra percentage to kind of reflect the added difficulty of both sides of your body being impaired. That comes from 38 CFR 4.26. Ideally, this is supposed to boost your rating automatically, and VA should do this without the veteran even needing to request it. But it does get messed up sometimes. They might forget to apply it. It doesn't create a new rating, but it does help veterans get to a higher combined percentage when they have both sides of their body impaired.
Yes. The next term we have is pyramiding. Maybe you've heard of this one. Sounds a little weird. Essentially, pyramiding is VA's rule that prevents paying for the same manifestation of symptoms twice. So there's a regulation at 38 CFR 4.14. It says that VA cannot compensate the same functional impairment under multiple diagnostic codes. So the key with pyramiding, if you have a decision that says that to assign increased compensation would result in pyramiding, the key is that VA will not pay in benefits for the same manifestation, even if the injuries involved are different. So there's a little complicated. I think a good example comes from the seminal court case on this issue, which is Esteban v. Brown. In that case, Mr. Esteban had a facial injury in service. It resulted in a painful scar. It resulted in disfigurement, and it also resulted in difficulty chewing because of muscle damage. So that's one injury that's causing multiple different manifestations. And when he applied for benefits, VA did not compensate him for those 3 different distinct manifestations of his facial injury. So he appealed to court, something that we have to do all the time here. And the court clarified that because the one injury resulted in 3 distinct manifestations of symptoms, a painful scar, disfigurement, and difficulty chewing, it would not result in pyramiding, which is like the forbidden thing, to pay him separately for those distinct manifestations. So if you have an issue where VA is saying that compensation would result in pyramiding, you want to focus on the distinct ways that the injury or condition affects distinct bodily functions, different kinds of earning capacity impairment, like Ethan was mentioning. And that's the best way to look at that situation if VA thinks that they're assigning duplicative compensation. It won't be duplicative if there are distinct manifestations that you can point to.
Right. So next up is VA math. This is probably one of the more complicated areas of VA law in general. Veterans often ask why, if they have 2 conditions rated at 50%, they're not getting paid at a 100% combined rate. And the answer is VA math. So VA has its own formula and ratings table in 38 CFR 4.25, and it adds up your ratings differently than just 50 plus 50 equals 100. Each new rating is basically applied to what they consider left of your earning capacity that is not already being compensated for. So bear with me, this is kind of a long walk, but if you are rated combined at 90%, you might think, oh, if I just get one more rating at 10%, they'll be paying me at 100. Actually, you would need something at 50% or more because they are calculating that additional bump based off that remaining 10% of your earning capacity. They need to show that you're over half of that remaining 10% is impaired to pay you for 100. It's very complicated. I don't think there's hardly anyone even who has been practicing veterans law for a really long time who doesn't need to use our ratings calculator or some resource to do this. It's not just a straightforward formula. I think it's like algorithmic. They have their own system to do this. It's counterintuitive and it can be frustrating, but it is required by regulation. So understanding this just helps you set realistic expectations for how your compensation can change. And it can help you kind of spot calculation errors if you feel VA is not paying you correctly. It's just important to keep in mind that it's not simple addition. There is a lot more complicated math going on there. And then the higher your combined percentage already is, the higher ratings you will need to actually increase it.
Exactly. There is a chart in the regulations where you can, I've done this before, but not very often.
No.
There's a chart where you can line up your current ratings and then what additional ratings would increase your compensation to the next 10-point scheduler criteria. But as Ethan mentioned, we have a calculator. There's a few of these online.
Yeah.
And we recommend using that if you are curious about why a rating percentage increase, maybe for one condition, did not result in a total combined rating increase, because the answer is going to be VA math.
Yeah.
Next two terms, severance and reduction. These are similar, so we'll handle them at the same time. A reduction is when VA institutes a process to reduce a service-connected disability rating that's in place. Sometimes VA will send claimants to exams. Those exams will reveal that there's been some improvement in a condition, and usually incorrectly, VA will propose to reduce that person's rating. A severance is when VA wants to remove service connection for a condition entirely. So a reduction still keeps service connection intact, but a severance is effectively VA saying service connection is not in order and should not have been granted in the first place. These are very tricky, frustrating, and really difficult situations we find in our practice that veterans find themselves in if VA is going through the process of reducing a rating or severing service connection. Of course, there are some conditions that by their nature are expected to improve, such as sometimes cancers with effective treatment. But there's a lot of other conditions that only progressively worsen over time, generally speaking. And so getting a reduction for those ratings can be really frustrating. So we recommend reading the notice letters for sure, very carefully. VA has a series of due process rules that they need to follow. They need to propose to make a reduction or a severance if it would impact your monthly compensation. They need to allow you a period of time within which to respond. You can request a hearing if you'd like. You can submit evidence to rebut what VA is saying as the basis for the reduction or the severance. So pay attention to the paperwork in those cases. But yeah, if you're getting papers that talk about reduction or severance, that's the story. And I think the biggest takeaway is just to remember that due process applies and you have an opportunity to respond.
For sure. So lastly, we have functional loss. So functional loss is most important with orthopedic or musculoskeletal conditions. The regulations basically say that VA has to consider not just the range of motion results, but the way that these conditions impact your daily functioning and your ability to actually use your body part, including during flare-ups. The court really reinforced this in DeLuca v. Brown and some other cases since that time. The gist is that the range of motion numbers when you get tested for your joint disability is not the whole story. You might still have decent range of motion, but your knee limits your ability to walk or stand, for example. Your back makes it really hard to bend over. These are impairments to your ability to use your body part in daily life, and VA has to consider that evidence when they're rating your condition. And not just purely rely on those range of motion numbers.
Great. So these are terms that show up all the time. We see them all the time in our job, and veterans out there who are going through the appeals process might see confusing terms like these. We hope that this helps to clarify some of what you're seeing. And of course, we always recommend that if you have residual questions that you feel like you can't answer, definitely speak with an accredited representative who can help you navigate the legal jargon that kind of comes along with this process. In this next segment, we're going to walk through a practical guide to requesting evidence for VA claims. Most veterans are denied benefits because they haven't submitted or because VA has not obtained helpful evidence that can help them win their claim. So the right evidence and having that in your record is really, really critical if you're involved in a claim benefit seeking process. So today we're focusing on some practical stuff, some logistics, how to get evidence, how to submit it, and things around that. So Ethan, can you start with sort of the big picture? Like, what is the burden for individuals in the process to be submitting evidence to help their own claim along? And does VA have any burden to assist? Sure.
So in general, under the law, the burden is on the veteran to support their claim. That comes from a statute passed by Congress, 38 U.S.C. 5107A. Essentially, the veteran has the obligation to prove evidence that a disability is at least as likely as not caused by service or service-connected disability. So in other words, at least 50% likely that this is the cause. However, VA does have a duty to assist veterans and help them gather evidence to support their claim. That's under 38 U.S.C. 5103A. Big A, not little a. They're different.
Very important.
So VA does have an obligation to make reasonable efforts to help veterans gather evidence once VA knows it exists. So there's still an obligation for the veteran to tell VA where the evidence is and to give permission to request it. So for example, if you're treating with a private doctor and you want VA to get those medical records, you need to tell VA where you're treating and then give them your signed permission to access those medical records. And that's why requests and identifying where this evidence lives is really important. A strong claim usually involves multiple types of evidence. So your records from service, your current medical records, and also lay statements from yourself or family or friends that kind of describe your symptoms and the history of your condition. And then VA looks at all of this under 38 CFR 3.159, and that talks about what counts as competent, helpful evidence and how VA is actually going to receive it.
Great. Let's talk now about military records. That was a great intro, and thank you, Ethan, for going through all of that. Military records are sort of an outlier.
Mm-hmm.
They belong to the Department of Defense for the most part. So requesting military records is different than requesting medical records that a veteran can usually personally access more easily, that VA can access. Military records include service treatment records, personnel records, in-service performance evaluations, line of duty reports, discharge status information. These pieces of evidence can be really critical in especially a service connection claim. If you're trying to prove the occurrence of an event in service, or perhaps the occurrence of a stressor or psychiatric event that resulted in a decline in performance, for example, then your service records can be really powerful evidence that VA will want to adjudicate your claim. I have to say more recently, because of e-records and the easier transmission of paperwork nowadays, I see that these records are in our clients' files pretty routinely.
Mm-hmm.
But if you served a long time ago, or if for some reason VA did not get your service records, you want to think about submitting a form to request them from the service department. So the form is the standard form 180 or the SF 180. And this allows you to submit a written request to the National Personnel Record Center, the NPRC, and that will help to effectuate the transmittal of your service records into your VA file, which again is really important.
So next up is private medical records. So VA can't automatically get medical records from civilian doctors or hospitals or clinics without your permission due to medical privacy laws. So if you're treating at a non-VA facility, you need to authorize VA to request those records. You're going to do that through VA Form 4142 and 4142A, and identify where you're getting treatment and then give them your signature so they can request these. Our practical tip, though, is don't just rely on VA to get this evidence. A lot of times the treatment providers might not respond to a request from VA. They might send incomplete records. You might get better results by actually calling your treatment provider directly and asking for your complete treatment notes, not just a summary or not just a small portion of it. And then make sure you request the records for a really broad period of time. You know, you might zero in on a specific year, but the broader the request, the more records they might be able to turn over. A good phrase or a good way to ask your treatment provider is, I need complete medical records, including your office notes, your testing, and physician assessments for a VA disability claim purposes. Again, VA does have to make some reasonable efforts to help you get those under 38 CFR 3.159C1. But incomplete records are a pretty common problem that we see, or providers just not responding to requests from VA. So we always recommend, if you can, call the treatment provider and ask them for those records.
Totally agree. Next, let's talk about medical opinions. These are different from treatment records because medical opinions that can really help with a VA case include specific nexus opinions. We've talked a lot today about nexus. Nexus is the element of service connection where there's a medical link between an in-service event and a current disability. So these are really powerful pieces of evidence in your case. And they're not things that VA will just obtain on their own. Of course, they'll send claimants to C&P exams, compensation and pension examinations, but you may be considering obtaining a medical opinion to support in your case for your own benefit and for VA's review. So if you're requesting a medical opinion from a doctor, you need to think about asking the doctor to address what's your current diagnosis. That will help to frame in the issue for which you're seeking benefits. What's your service history? So in other words, what's the in-service event that this diagnosis could be linked to? And then the magic words for a medical opinion or a nexus opinion are, is it at least as likely as not that the condition arose from service? And this phrasing is critical. It comes from case law like Gilbert v. Derwinski. It's been mentioned in a million other cases, I'm sure, because this is the prevailing evidentiary burden of proof standard that applies to claimants. Is it at least as likely as not? Is the evidence at least approximately balanced as to whether the benefit is warranted? So it can be really helpful to obtain a medical opinion from your treating doctor or from another doctor that can speak to a potential nexus between a service, an in-service event or onset, and the current disability that you now have.
So that brings us to lay statements, which are actually pretty underused by veterans and claimants to support their claim. Lay statement or layperson refers to a statement by someone who doesn't have medical expertise or training, a statement from an ordinary witness, essentially. Lay evidence is allowed to support claims under 38 CFR 3.159A2, a lot of numbers and letters there, and confirmed by cases like John Doe v. Nicholson. Lay statements from the veteran or from family or friends or coworkers, other service members can really help establish what happened to them in service, for example, an injury and symptoms, when the symptoms started, and also how those conditions affect your daily life or work. It's important, though, that these statements don't guess at diagnoses or causes of a disability, because those are things that require medical training. Mm-hmm. Again, this is something that the layperson observed, personally saw, or experienced. You can use a standardized form to submit these, VA Form 214138, or a signed letter on a blank piece of paper. The form is helpful for use, but it's not required to submit a lay statement. And kind of the good guide to lay witnesses or lay statements is focus on how you know the veteran, what you observed, when you observed it, and how often. So a statement about PTSD would focus on when the symptoms began, how severe they are, and what you see from the veteran, how they behave, and what you encounter. But it wouldn't guess at what's causing it or use too much medical terminology or lingo. It's really about being straightforward and direct with what you've witnessed.
Great. All super helpful. And we'll close with some practical advice about following up on outstanding requests for records. So we've talked about a lot of different ways to procure evidence that's useful in your case. But as Ethan mentioned, and I think maybe I mentioned it too, we can't just rely on VA to finish the drill and carry the ball and get it all done. You want to be playing an active role in the acquisition of records that will help your case. So as Ethan mentioned before, sometimes VA will be seeking treatment records, for example, and a provider just won't send them to VA. You want to be following up on these requests, maybe nudging your provider along. Hey, VA is going to be reaching out. Please send my file. Or can I please have a copy of my file so that I can send it to VA? Just think about keeping the records in your hands if you can. Obtaining copies of whatever is being submitted in your file can be really helpful. If VA cannot find records or they can't obtain them from the source that they're requesting them from, they're required to issue a formal finding of unavailability. That comes into play more, I feel like, with service records, because if the service department cannot find your service records, then that's a pretty rare event, but it does happen. And in those instances, you want to be aware of when VA is making those findings. You want an opportunity to respond. And you want to ask VA, is there any other alternative evidence that would satisfy this request? So just thinking practically, keep copies yourself of whatever you can. Sometimes submitting things to VA will just get the job done more quickly. And also be paying attention to those follow-up notices that VA is sending. You'll get copies of them in the mail, and they can be a good tip for you that maybe they're not able to obtain something from a provider. And then that's a cue for you to step in and maybe help things along. Okay, our last segment for today, we're talking about which VA disability cases tend to be the hardest for claimants to win. We're going to talk a little bit, kind of in rapid fire style, about why they're difficult and what kinds of evidence or preparation can really help to make the difference. We're going to be talking about cases that are difficult to win. In no way are we saying that these are hopeless or unwinnable. That's not true at all. If you feel like you are dealing with a hopeless or unwinnable case, I bet you that we can convince you otherwise. Usually these cases are defined by a quirky or very involved legal standard or a very specific evidentiary burden. So hopefully going through some of the hardest things that we see in our practice will help you understand if you're dealing with a particularly complex case that might need some extra attention. So let's first start with clear and unmistakable error. Clear and unmistakable error cases are very difficult to win because they require satisfying a very complex legal burden. So a motion for clear and unmistakable error is one where a veteran might say a decision that was made a long time ago that was never appealed was clearly and unmistakably wrong, and that VA should correct that error. These errors have to be undebatable. They have to be things that no reasonable person could view differently. They have to be very obvious errors. So it can't just be something where one person sees it one way and another sees it the other way. These things have to be truly undebatably erroneous. Disagreeing with how VA weighed evidence isn't enough. And I think I'm stealing your thunder here, Ethan.
That's okay. Yeah, but that's exactly right. If VA looked at two medical opinions, for example, one's favorable to the veteran, one's unfavorable, they picked the unfavorable one. That's probably not going to be a cue because hypothetically, a reasonable person could disagree with which opinion to pick. And they might differ over the outcome there. It has to be really precise and specific about what VA did wrong. So you need to specify, did VA apply the law incorrectly? Did they ignore facts or evidence that was already in the file? Did they not give you a presumption that you were legally entitled to? It has to be framed correctly and specifically, or VA might just deny it on technical grounds. And that's really what makes these Q claims challenging.
Exactly. Another challenging type of claim, 1151 claims. These are essentially VA medical negligence claims. They're very difficult because you need to prove something that's sort of similar to tantamount to medical malpractice, but through VA's regulations and processes. So VA has their own regulation that governs what sort of burden you have to prove in order to be successful. So in plain English, you generally need to show that you have an additional disability caused by the medical treatment. It was caused by VA medical care, surgery, medications, or vocational rehabilitation. And it was due to negligence or an event that was not reasonably foreseeable in the conduct of that treatment.
What makes these so difficult is that they really require strong medical evidence. So that usually includes a private medical opinion that addresses what were the known risks of this procedure, what's the usual standard of care, and explaining why what VA did was so negligent or so unforeseen. VA will often argue that something was a known risk of a surgery or it wasn't caused by the VA treatment or just would occur naturally as part of the condition. So disproving that requires medical evidence directly, and getting that evidence can be pretty difficult for veterans.
Exactly. A next really difficult case can be if VA says that the presumption of soundness does not apply. What makes the presumption of soundness concept so difficult? This applies to your entrance exam and essentially the state that a veteran was in at the time they entered service. The law presumes that veterans who entered service were sound or healthy or without disability, except as to things that were specifically noted on entry. These are tricky cases because sometimes VA will deny service connection and say, we can't give you benefits for that. It didn't come from service. It pre-existed service. And that's where you might end up in a very sticky sort of legal theory world where you need to sort of unpack how the condition either did not pre-exist service, the presumption of soundness should apply, or even if the presumption of soundness doesn't apply, why you can still prevail in this type of case.
Yeah, and what really makes these challenging is that they're all about details. Having argued these cases at court and at VA, it's all about what was listed on your entrance exam, what happened in service, was it documented in service treatment records, or did you not seek treatment? What do examiners say about did your condition worsen in service or already exist before service? And that there are so many different factors there that can make these really difficult. A really common problem with these presumption of soundness cases is that VA will rely on medical evidence that is really weak or unsupported, just saying that your condition didn't get worse because of service, but not explaining why or what basis they have to make that conclusion. These cases can be winnable, and CCK has certainly won a good amount of them, but they require a lot of attention to detail, a lot of specifics, and a lot of focus on the entire history of the condition prior to service or during service.
Exactly. And on a similar theme, aggravation of pre-service conditions. These are really, really tricky. Again, because of the legal standard that applies, the presumption of soundness is sort of in play here too. So with an aggravation claim, a person's generally asserting that a pre-existing condition, a condition that existed prior to service, became permanently worse during service beyond what would have happened naturally in the context of that disability, such that service connection should be granted. And these are difficult because you all often need to establish a baseline, meaning that the condition was at a particular level of severity before service. You also need to show evidence of worsening during service beyond the natural progression of the condition, and a medical explanation that connects the dots. Why is the condition that you now have permanently worse because of in-service events? VA frequently denies these claims based on inadequate exams performed by VA contract examiners. Classic. They often do not do the in-depth review of medical records and the claimant's file to be able to determine the baseline and the in-service worsening that occurred that would provide a pathway to getting benefits.
So the evidence strategy for these claims really focuses on service records, lay statements describing what happened in service, medical opinions addressing the condition during service, really a lot of evidence explaining why why service made this condition permanently worse than it would have been otherwise, and why what happened to you in service was kind of the dispositive factor for the condition getting worse.
Exactly. Radiation exposure claims. Wow. This is just a list of all the hardest cases that we come across, but it's important to talk about them because these are tricky and complex, but like we mentioned before, they're not hopeless and they're not unwinnable. So specifically, why do I have such baggage with radiation exposure claims? These are really complex because they involve proving radiation exposure based on dose estimates. If you read the regulations about these, they're highly technical, very specific. So you need evidence that proves your claim, like specialized service verification. You need a medical nexus that links radiation to the disability that you're now claiming. And different rules can apply depending on the type of exposure, like atmospheric testing, Hiroshima and Nagasaki occupation, nuclear weapons work, or medical and industrial exposures. So there's all type of different radiation exposures that could occur. They have different rules attached to them. The dose estimates are complex, different units of measure than you've ever seen before. So these can be really, really technical cases. Right.
And they can often stall out or be denied as incomplete because VA will often get advisory opinions or request additional records or dosage estimates of how much radiation they think you received. Veterans are often going to need really specific evidence about not just where you served, but what your duties were that would have exposed you to this radiation. Proving that you got enough radiation doing these duties to be harmful, and you still need to prove a link between that radiation and your current disability. So you'll definitely want to review the regulation. That's 38 CFR 3.309, kind of learn about locations VA will automatically treat as causing radiation exposure. Like Maura mentioned, it is a really complicated regulation. Your eyes might start to cross reading it, but don't give up. There is a way to win these claims. You just need to be as specific and provide as much evidence in support of it as you can.
Totally. Next, we'll move on to protected work environment cases. A protected work environment case is one where we are usually helping a veteran secure TDIU or a total disability rating based on individual unemployability. But in a protected work case, the veteran is actually still working. But for their work in a protected environment, they would not be able to maintain a competitive job in the market, and they can be entitled to TDIU benefits despite that work. These are hard because VA tends to see things in pretty black and white terms. You either are working or you aren't, and if you are working, VA is not inclined to grant you TDIU. But a protected work environment is a very specific sort of middle point where, as I mentioned, the protections that your employer provides are the only things essentially that are keeping you employed, that are allowing you to engage in employment. And but for those protections, which are usually afforded to veterans by employers who have knowledge of their medical conditions, their service, and a lot of employers are also trying to help veterans by keeping them employed, by offering them a protected and highly accommodated job situation. But for all of that, you would not be able to work because of service-connected issues.
Yeah, what makes these cases really hard is that VA rarely concedes a protected work environment, like you said, but also there's not really a solid definition for what a protected work environment even means.
Yep.
It's determined on a case-by-case basis, and there's not one clean definition that fits all of these.
Yep.
What VA is really looking for is, one, the job is considered a lower income position. Again, there's not a clear definition of how much money that is, but they want it to be lower income. And second, that the accommodations you're getting from your employer are what they call unreasonable or above and beyond what an ordinary employer would provide. So even accommodations under the Americans with Disabilities Act might not be enough to show a protected work environment because those are pretty reasonable and standard. What they're really looking for, like you said, is that without these accommodations, the veteran would not be able to work in this job at all, not just accommodations that make it easier to perform the tasks.
And another key piece of these cases is getting employer evidence.
Mm-hmm.
We can't recommend that enough if you're fighting a protected work environment case. Really think about whether your employer can help to substantiate the unreasonable extreme accommodations that they're providing.
Yeah, things like a write-up of your accommodations, your attendance records showing that you're allowed to leave or miss work, as needed. Exceptions to your performance, statements from your coworkers showing that you don't have to do things that all other coworkers have to do, what your earnings are, showing that you couldn't be competitive in the workplace without this job. It's a lot, and the burden is pretty high on the veteran to prove it, which means that VA oftentimes will really fight veterans on showing a protected work environment.
Exactly. Next up, we have PTSD stressor verification. So again, VA thinks black and white. And if you are asserting the occurrence of an in-service stressor that led to the development of a psychiatric illness in and after service, it can be very difficult to get VA to concede the occurrence of the in-service stressor without specific evidence that speaks to the fact that you were present during that stressor. Now, why is this difficult? Because VA will often refuse to admit that a stressor is verified. Stressors by their nature can be circumstances that are difficult to prove and that evade medical or even just paperwork, any documentation. So sometimes veterans will be present during service in a combat zone, and maybe VA will not concede that, but their lay testimony around what they experienced in service certainly does indicate the occurrence of a stressor. Another common example is with military sexual trauma. These are events that are often not documented, and so VA has a difficult time conceding and verifying the occurrence of a stressor, like an MST, in the absence of clear documentation, which I think is the crux of why these are tricky cases to win.
So a lot of times what these cases turn on is showing that there are some sort of marker or indication in service that VA considers a typical or common response to trauma or personal assault. This can be a decline in performance, an unexplained change in behavior, seeking STD testing, requesting to move units away from an assailant, or even showing that psychiatric symptoms began shortly after the stressor occurred. A big problem, though, as you mentioned, is that a lot of times survivors or people who have stressors don't report these at the time. It's only later that they even feel comfortable talking about it. So we see commonly that there are missing records or inconsistent exam findings, or something is not documented in the service records, and then VA not really considering your lay statement where you describe what happened to you in service. So these cases can absolutely be won, but they require a specific evidentiary approach, especially if it's not documented in the service records. You'll need to look for other ways to support, that this stressor happened and that your behavior changed after it. And
now we'll move to the last tricky case on our list, which is earlier effective date cases pursuant to 38 CFR 3.156C. Personal favorite of mine. What makes these cases really hard to win is that there's a specific avenue in the regulation that says if you file for benefits for a condition and VA denies, we're often seeing this in the context of psychiatric conditions too. If VA denies and then years later they associate service department records, which is a very specific type of record, they have to come from the service departments, or be related to, be otherwise falling into the definition of a service department. If VA later receives service department records that were not of record at the time of the first denial and that were relevant to the claim or to the issue, then VA needs to reconsider in a way that sort of like reopens the older claim. These can be really powerful arguments in cases where a prior denial was not appealed. So there's no continuous pursuit chain going that would entitle a veteran to like an easy award of retroactive benefits if they win. So this regulation has the effect of allowing veterans to reopen a previously denied claim if Service Department records were later found, discovered, declassified, and associated with that veteran's file.
Yeah, and these cases are hard because they're just not very common. It's not often that VA misses a chunk of service records that already existed and fails to associate it with the file. And it really turns on the history of not just what happened to you in service, but VA requesting the records, VA overlooking a chunk of service records when they were added to the file, and kind of factual accuracy about what they show happened to you in service. So small errors in how VA does this can really change the outcome of a decision and push your effective date years back. But it is not a very common thing that we see, and it can be a pretty tough burden to show that VA missed part of documented service records because, like you mentioned, generally that's one of the first things they request for a claim.
Exactly. So in closing, if you're pursuing one of these trickier, harder cases to win, Ethan had a lot of good tips. Focus on building the record strategically. Focus on supplying VA with the right documents they need, the right timeline, and specific medical opinions that really address the discrete issue that's involved in these cases. And again, we've said this a bunch of times today, but it's often worth consulting an accredited agent or attorney that can help you navigate the more specific, precise, and difficult legal burdens that apply to cases like these. And that's our episode for today. Thank you all so much for tuning into the Veterans Legal Lowdown and being here with us today. Please be sure to like and subscribe to our channel so that you don't miss content like this video in the future. And in closing, take care of yourselves, take care of each other, and as always, keep the fight alive.
Keep the fight alive. Thanks, y'all.
We'll see you next time.